Hello, today we're going to speak about illegal occupation of your property or your holy homes in Spain. We will be recommending you as an owner which is your legal situations and what recommendations we will give you in order to put the squatters out of the property. Anyone who suffers the squatting, ocupas, as we say in Spain, for our property, has several legal alternatives currently in forms to recover your property. In one hand, there is a criminal route, a criminal path, by obviously starting a criminal action, by filing a criminal action in order to someone who has trespassed or, as we said in Spanish, usurpation of your property, depending whether it is a permanent or a holiday home. On the other hand, we have a civil route, a civil path, which is express and rapid procedure on litigation in force since July 2018. Normally happens that in summertime there is the highest number of people which travels and leaves the properties and coming to Spain or living in Spain, and also is the highest number of empty properties, empty homes. And what happens sometimes on returning from holidays, people which is in Spain living and outside, then some citizens have found your property is illegally occupied, and many others, well, obviously fear that on returning from the second residence, which is also a situation, from, for example, a beach flat, a mountain flat, or a village, a country house, it may be subject to ocupas, to squatting. The use of one of the legal routes will depend on various factors related to the conditions of the occupants that may affect the characteristics of the property, the causes that the affected owner can assume, obviously, and the time of the occupation, and even which is going to be the jurisdiction, the competent court is going to be taken on this. Okay, so as I said, there are two routes. One of them is criminal path on the civil area. The criminal proceedings are started by filing a denuncia, which is a denuncia or a complaint, with the police at the police stations or at the Guardia Civil, the civil ward, closest to the occupied property. This complaint, this denuncia, is free, and it will be started and continued. By the prosecutor will be pursued by him or her. We call it with ex officio. Ex officio means that it's going to be done by the courts, it's going to be done by the prosecutor, it's going to be made at the end by the police. So anyone who illegally occupies your property, and obviously your property is your permanent home, or maybe it's a second residence, a holiday home, will be punished. Anyone who occupies your property will be punished with the crime of breaking and entering your property. Briefly, what says the criminal code? The penal code says from prison from 6 to 2 years, but if the occupation is carried out with violence or intimidations, and we say violencia o intimidación in Spanish, the penalty will be prison from 1 to 4 years, and will also be a fine. What are the requirements that you need to report in the police station? Which requirements you need to show in order to make a denuncia? Well, those requirements start with proving first that you are the owner of the property. So how do you prove that you are the owner of the property? Well, not as simply information from the property registry and the copy of the deed, for example. And also whether if your main home or your holiday home, you will have to show maybe you have a padrón, you are inscribed in the municipality that you are living, or as a holiday home. That's extremely important. In addition, if possible, it is advisable to provide information about the occupants. How many of them, the possibility that they are a criminal group maybe, problems of cohabitation with neighbors, and obviously to provide witnesses from neighbors to prove the circumstances of the occupations and the ownership of the property. It is possible to recover the house through a police action. Well, regardless of the court process that will be opened in order to punish the occupation, in order to punish the illegal occupation, the police obviously can enter to identify, arrest, and put an end to this. We call it is a crime. This occupation, this illegal occupation, it is a crime. So the argument is that the offense continues to be committed while the squatters are in the occupied property, the crime is being done at the same time. So this is why the police has arguments in order to enter and, as I said, put an end to this crime. However, the police should have not doubt that the crime is being committed in order to evict, obviously, the occupants. In fact, there are some reports, such as those issued in 2018 by some high prosecutor on Balearic Island and also in Valencia. On the other hand, that the police have a right to evict immediately without the intervention of a judge when the agents see that the situation is obviously clear. Okay, and on the other hand, some prosecutors obviously have to request eviction as a preventive measure, precautionary measure, preventive measures in all cases. This is something that needs to be applied by the prosecutor. Important, there is no general rules setting a deadline for the police to evict squatters, to evict occupants. And this legend that says that the police can only act in the first 48 hours to remove those criminals that are occupying your property, it is a legend or it is a fiction, okay? There's nothing about that. Will be or can be the judge can approve the injunction to evict rapidly. Well, in Spanish is Ley de Enjuiciamiento Criminal, the Criminal Litigation Act or Procedure Act allows the judge to adopt all those measures that are necessary to preserve and protect the ownership of a property by obviously evicting the squatters, the occupants, and recovering the property within a few days. That's important. To this end, the judge, whether there are relevant indications that a crime has been committed, and obviously the owner has shown as an owner, is proving that he's the owner, and will take into account these issues and also about the damage that may happen or may occur, the deterioration of the property, and also to see if the property is going to be, or it is, let's say in a long term, over time, occupied. All these issues is analyzed by the judge in order to start the injunction to evict or not, which is at the end the proportionality of the damage to the owner, because someone who has a property, is living in the property, has a habitual property, is being occupied by some occupants or squatters, so they cannot live in their property, and also damage also to the possible neighbors, and also obviously the vulnerability of whoever is the occupant. Okay, eviction in many cases is usually a matter of hours. Okay, how long can this criminal procedure take? And we still are in the criminal path. Okay, if the person affected by the squatting, by the occupants, does not succeed in obtaining an injunction rapidly for eviction, it will be necessary to wait for the resolution of entire criminal procedure. Normally it takes some time, in which case the procedure could take, I would say, between more than a year, for sure, than a year, okay? What to do when a property, empty property, is taken over by occupants, by squatters? When the occupied property is not your main home and it's not your holiday home, or second residence, it is considered to be an empty property. Okay, this is important, an empty property. In this case, the occupation, the illegal occupation is a different, it's usurpation of a real estate, of property, and obviously is punished in the criminal code in Spain with a fine, and even though it's done by violence or intimidation, will be considered and will be some situation where can be applied some prison resolution from, I think it's from 1 to 2 years. But in this case, as in the case of breaking and entering, it is necessary to file a complaint with the court. Okay, but the procedure is longer in this case of empty properties. It's different if it is a main home or a holiday home, a second residency. When it is an empty property, is obviously different and will take longer. And obviously, the prosecutor or your lawyer, your barrister, will have to apply also through preventive measures in order to to start eviction, the eviction before. The squatting scenario, the squatting phenomenon, basically normally in many occasions occurs with empty property, as I said. Normally occurs with us ones, which are obviously neither your main home or your second home. How do the police deal with this criminal situation? It is not your home and it is a minor offense. The police normally intervene when they enter the property, when it's committed, when it's infraganti, we say infraganti, which is being committed, or even that a complaint needs to be filed immediately. This is what barrister will recommend. Whenever you understand it's being done, try to file a denuncia. You need to submit in the police station the denuncia in order to do it immediately. That's a must. That's extremely important. And obviously there happens many situations where the squatters often create a lie. I mean, they say, well, I'm here because I have a contract, and they appear with a false contract. And they lie with sufficient legality. They say, well, to the police, well, I'm here because I have a rental contract, as I said, or this utility bill, I'm paying it, or whatever they may say. Obviously, the agents they perfectly know they are being used, obviously, about this. And it is common that the occupant will argue like in a state of necessity and need. They don't have any property, they just can live there. But it's also, as I said at the beginning, there is a civil action you can start, a civil path. And from 2018, we have an express, a rapid proceeding in order to apply and put the squatters out of your property. With this new, let's say, amendment or change on this law in 2018, this express proceeding aims to speed up the deadlines and reduce the requirements for owners to evict the occupiers, the squatters. What are the main features of this express claim? The squatters, the occupiers, have 5 days to prove that they have legitimative title to occupy the property. Otherwise, court order will order the immediate eviction or immediate eviction of possession of a property to whoever applies for. And the court also will transfer the claim to the social services in order to avoid situation of social exclusion, which in many cases will delay the eviction procedure. For example, whenever there are children or whenever they don't have enough money to live, they don't have basic things to live. How to file a lawsuit, how to start civil action. A civil action must be filed in the court. Whatever the courts are in the territory where you have a property will be competent in order to admit and get the court actions from you. Obviously, you will need a barrister and you will need also a procurador, a solicitor, or a court runner. The claim must prove that the ownership of the occupied property, so as I said before, as well as the criminal action. I mean, you need to show that you are the owner, you need to show that you, with the land registry information, with a copy of the deed, and important, and they request the immediate eviction of the occupiers, of the squatters, and provide the evidence deemed necessary to prove the time and circumstances in which the occupation took place. It is important that, and this is extremely important, no more than 1 year must have elapsed since the squatter entered into the property. Otherwise, civil proceeding will offer the possibility to start eviction, but with slower alternatives. How long it takes to repossess the property to you? Well, this is a question that is made by all the clients, and it's difficult to answer, really. The civil action is obviously designed by the government in order to resolve and put the keys in as soon as possible, say days, weeks, as less months as possible. When the squatters do not present in those 5 days the titles or documents that shows proof that they are legally in that property. And the applicant can request, obviously, the immediate surrender of a property, and the judge, even before issuing a resolution, as I said, we will open a period of 5 days for the defendants, the demandants, to provide a title to prove that they have a right to stay there. As I said before, sometimes they prove, or they want to prove with a false contract with someone who has been there and renting the property to them, which is obviously false, but they need to prove why they are on the property, if they have any legal issue or anything to say. If they do not justify why they are there, if they do not justify the occupation, the court order will immediately will make handing over of a property to the owner. Important, no appeal is possible against this decision by the judge. And the eviction will be carried out against any of the occupants who were in the property at the time. In practice, this proceeding can take at least 6 months or more. If you read in the internet, someone will say 4, 5, 6, sometimes even more. It is more realistic to speak that sometimes these delays in order to recover the property, both in criminal and also in civil proceeding. Except, as I said at the beginning, in case there is a flagrante delicto, in cases they are doing this crime situation where the public force can proceed and act rapidly and with force, and without any need of any court decision, as I said at the beginning, just because of the police. So clearly they are doing this crime, and they can take over these criminals, these occupiers, these squatters out of the property. What should never be done, and this happens a lot, and this is something that I want to repeat, what should never be done is that squatters are living in the property that is your property, is being occupied, your property, are using water, are using electricity, are using gas, and the owner may say, okay, well, I'm going to cut off all these provisions of electricity or gas or electricity, water. Well, if someone makes that, if an owner makes that, it will be in a situation, will be acting as a crime of coercion, crime of, in Spanish we say coacciones. So you never have to do that. You never have to do that. You have to take the criminal path, as I said at the beginning, or the civil action. Obviously, it is not advisable as well to fall into a desperation. It happens also with many owners by entering the property rapidly and change the lock. Do not do that. Do not change the lock and do not cut off the water, electricity, and gas, because this will be considered as a criminal action as well. Thank you. I hope we have informed you in this video, and we hope that you see this video useful. If you have any question, please do not hesitate to contact us.